Hello, my name is Matt Bechtel. I'm an attorney with the Green Law Group. The Green Law Group is a full-service law firm located in Simi Valley, California. Our primary practice areas are construction law, business law, employment law, bankruptcy, and real estate law. I've been an attorney for approximately 12 years. My practice ever since the start has consisted primarily of employment law or employment benefits law. I represent both employers and employees in legal disputes related to employment. Today, we're going to be talking about new employment laws that go into effect on January 1st, 2021. The next slide. So before we get started, just a fair warning, everything that we talk about today is for general information only. While we do strive to make sure it's accurate and a general overview of the law tends to be very fact specific, and there may be specifics in the law that we would have to know the facts of your case before opining on anything. So anything I say today should be considered general information and should not be construed as legal advice. Now, every year in California, there's about a dozen to 24 new employment-related laws that go into effect. This year, there's about 20 new laws, or I should say, beginning January 1st, 2021, there will be about 20 new employment-related laws. Today, we're going to talk about 7 of them in particular. The laws we're not going to talk about generally are very industry specific. For example, there are several laws related to healthcare workers and specifically hospitals and PPE. There's other laws related to, for example, carriers for newspapers that are just very specific and outside the scope of today's presentation. Today we'll be talking about 7 laws that are generally applicable to a wide range of companies and employers. Those laws include AB 685, which is a new requirement that allows California OSHA to keep track of COVID cases in California. AB 979, which is a corporate board diversity law that requires boards of publicly held corporations to be more diverse. AB 1281, which is really just an extension of an exemption for a privacy law that went into effect at the beginning of this year. AB 1947, which extends the statute of limitations for the Labor Commissioner to bring certain wrongful termination claims. AB 1963, which makes certain human resource professionals mandatory reporters. AB 3075, which requires companies in California, fictitious entities, to report on wage and hour judgments against them. And then finally, we're going to talk about SB 1383, which is a law that expands the California Family Rights Act to most employers in California. Next slide. So the first law is AB 685, which is a COVID notification requirement. Now, this law expands Cal OSHA's authority to keep track and enforce COVID violations. Now, there's really 3 major components to this law. The first component is AB 685 expands Cal OSHA's authority to issue stop work orders. The technical name for this is an order prohibiting use. Now, Cal OSHA has always had the ability to do this for unsafe working conditions, but AB 685 for the first time will allow them to issue stop work orders for COVID pandemic related reasons. And probably the most important thing about this new law, this aspect of the law, is the appeal rights are much more limited in the COVID cases than in any other cases. So as an employer moving forward, you want to make sure that you have a COVID prevention policy and that you actually follow the policy, because if you are notified by Cal OSHA to shut down, your ability to prevent that will be much more difficult. There are 2 major components that employers need to be aware of regarding AB 685. The first is a requirement that employers provide written notice to all of their employees of a potential COVID exposure. And the second is AB 685 requires employers to report COVID outbreaks to their local health department. Next slide. So with regards to exposure, notifying employees of exposure, when an employer receives notice of a potential exposure of COVID at a work site, beginning January 1st, 2021, they're going to be required to notify all other employees at the work site of the potential exposure. Now, potential exposure can come in many forms. It can include an employee reporting that they have a COVID diagnosis. It could be the employer learning about a COVID diagnosis through a company testing program, or it could be the employer learns about a diagnosis from a public health department or a staffing agency. If a employer is informed of a COVID infection or potential COVID exposure, they have to give notification to all employees at the same work site in writing, and it has to be communicated in a way that you typically communicate with your employees regarding employment-related matters. For example, if you typically use email to communicate with employees, email will be sufficient to give notice of the potential exposure. Similarly, if you use text to normally communicate with your employees, that also is okay as long as it's a normal method that you use to communicate to your employees. You do have to give this notice within 24 hours of learning, correct, 1 business day of learning about the potential exposure. You also must keep records of the notice for at least 3 years. This is typical with most employment laws in California, required to keep records for a minimum of 3 years. Now, the second component that's going to affect most employers is the outbreak reporting. Now, if you learn of an outbreak among your employees, you have a duty to report within 48 hours to the local health department. Now, an outbreak currently is defined as 3 or more laboratory confirmed cases of COVID-19 from employees in different households within a 2-week period. Now, this definition was provided by Cal OSHA. The law allows the definition of an outbreak to be defined in conjunction with local health authorities, so the actual definition might change in the local area. Now, the law requires that employers initially report the outbreak to the local health department within 48 hours. The initial report must include the names of the employees that are infected, the number of employees that are infected, their occupation, and the work site that they worked at. After the initial report, if an employer learns of additional cases, there's a duty to continually supplement and provide additional reports to the local health department. And it's important to note that all this information will be reported on the California Department of Public Health's website. Now, the California Department of Public Health will not report the personal information of your employees, but they will identify the employer and the number of cases and any other information that would allow the public to know the impact that the employer is having on the COVID pandemic. Next slide. So the next law we're going to talk about is AB 979, which is a new corporate board diversity law. Now, this law requires publicly held corporations with a principal office in California to have at least 1 director from an underrepresented community. Now, publicly held excludes most corporations in California. Publicly held basically means it's publicly traded. But if you're a publicly held corporation, you have until the end of 2021 to add a director from an underrepresented community. Now, the law defines an underrepresented community as an individual who self-identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or an Alaska Native, or anybody who self-identifies as gay, lesbian, bisexual, or transgender. Now, the law will be expanded even more in 2022. Beginning in January of 2022, corporations with over 4 but fewer than 9 directors will have to have at least 2 directors from an underrepresented community, and corporations with 9 or more directors will have to have at least 3 directors from an underrepresented community. The next law we're going to talk about is AB 1281, which is a really just an extension to the Consumer Privacy Act of 2018. So a little bit of background. In 2018, a law was passed called the California Consumer Privacy Act. Most people are familiar with this law, not necessarily by name, but by impact. If you're in California and you've logged onto a website recently, you've probably seen a pop-up at the bottom of your screen that began at the beginning of this year, January of 2020. The reason those pop-ups are there, and they're giving you the option to opt out of certain disclosure requirements. It's informing you that the website's tracking you through cookies or another means. The reason all of this is being done is because of the California Consumer Privacy Act that was passed in 2018 but became effective January of 2020. Now, even though the law primarily is concerned with consumer privacy, the law actually also applies to employers and documents and information collected by human resources. This would include information for your current employees, but also employees who, potential employees who applied and maybe were not even hired. Now, the important thing with this law is there was an exemption in the law that exempted human resource departments from complying with the law until January 1st of 2021. AB 1281 simply expands that or delays that until January 1st, 2022. So the good news is AB 1281 doesn't create a new obligation for you. It literally just gives you an extra year to make sure you're in compliance with regard to your employees. The law already applies to companies with regard to consumers, clients, and has some sections that actually relate to employees as well. So if you have any questions or concerns about what your obligations are under the California Consumer Privacy Act, the good news is you have more time to come into full compliance, but you should contact an attorney as soon as possible. The next law that we're going to talk about is AB 1947, which is an expansion of the statute of limitations for certain labor commissioner claims. So a little background. In California, there is a Department of Labor Standards Enforcement, which is a public agency that is charged with enforcing certain labor laws. Now, the DLSE, or Department of Labor Standards Enforcement, is overseen by a person known as the Labor Commissioner. Now, California law has always allowed the Labor Commissioner to pursue certain claims on behalf of itself or on behalf of employees. So there's really 2 ways that this tends to work out. One way is the Labor Commissioner identifies employers who are violating labor laws, and they bring an action on their own on behalf of the state against the employer to enforce compliance, and typically there is penalties that will be attached and that the Labor Commissioner is expressly authorized to seek against employers who don't follow labor laws. The second way that claims might come about is an employee makes a claim with the Labor Commissioner saying that their employer violated their rights. The Labor Commissioner has the authority to pursue claims on behalf of employees. Now, depending on what the claim is, there's different ways that this happens. Now, one set of claims in the form of discriminatory discharge, an employee has, under current law, has a duty to bring the claim to the Labor Commissioner within 6 months, and the Labor Commissioner has up to 3 years to file suit to enforce that claim. Now, what AB 1947 does is it expands the statute of limitations to 1 year. So now an employee would have to bring or notify the labor commissioner of the discriminatory discharge within a year of the discharge, and the labor commissioner still has 3 years to bring a claim. The law also allows employees to pursue a claim against the labor commissioner if the labor commissioner refuses to pursue a meritorious claim. One other major change that AB 1947 does is it authorizes the labor commissioner in certain discriminatory discharge cases to recover attorney's fees. Now, typically, the labor commissioner would not be able to get attorney's fees because it's a public official who is acting on behalf of the state and is funded by tax dollars. AB 1947 allows a court to determine what reasonable attorney's fees would have been had the labor commissioner been a private attorney, and to recover those attorney's fees against the employer. Now, we don't know the full impact that this will have on claims brought by the labor commissioner. It likely will result in additional claims being brought by the labor commissioner because they can now recover fees. And one of the biggest limitations the labor commissioner tends to have is lack of resources to pursue claims. Overall, this doesn't make a major change in the law for employers because employees were always able to pursue wrongful discharge claims against their employees without going through the labor commissioner. AB 1947 really just changes the rules for the labor commissioner and not for a private action by an attorney. So next law is AB 1963. Now this law, just a little background, there's a general principle in the law that basically says you can't penalize a person for failing to act. Now, like everything in the law, there is an exception to every rule. And one long-standing exception to this rule has always been, or at least since the 1980s in California, the child abuse and neglect reporting law. So typically, if you're a private citizen and you're come across or become aware of a child being abused or neglected, you have no legal duty whatsoever to notify law enforcement. You might be a bad human being for not doing so, but you will not be punished in any way for failing to do so. However, there are many exceptions built into the law, and these are known as mandatory reporters. Most people are familiar with this concept in some degree. So, for example, teachers, social workers, healthcare workers are all mandatory reporters, and if they learn of child abuse or neglect, they have a legal duty to notify either social services or law enforcement of their belief of the child abuse or neglect, and then it's investigated by either a social services agency or a law enforcement agency. But for most of us, we have no such duty. Now, what AB 1963 does is creates a new class of mandatory reporters for certain human resource employees. Now, this law only applies to employers that have 5 or more employees and who employ minors. But if you are such a company that employs minors and has 5 or more employees, you now have a few obligations. First, you have to train every employee who is a human resources employee about identifying and reporting child abuse and neglect. So the training requirement that you have to do, and there will be several ways you can comply with that training requirement. And the other thing you have to do is you have to have your employees notify law enforcement if they suspect any form of child abuse or neglect. Now, a human resources employee under this new law is defined as anybody designated by the employer to accept complaints of discrimination, harassment, or retaliation. So this will typically include, if you have an HR department, anybody in your HR department, but it'll also include most managerial or supervisory employees, since these employees typically, and most employers will have a policy that says you can bring complaints of discrimination or harassment to any management employee, sometimes any supervisory employee. So the next law we're going to talk about is AB 3075. Now, this is not actually an employment law. This is really a law that deals with corporate formation or business formation, but it overlaps with employment law and relates to employment law, which is why we included it on the list here. So what basically AB 3075 does is when you create a fictitious company, meaning a limited liability company or a corporation, you have to file certain documents with the Secretary of State. And initially when you form the company and every year or two after that, you also have to file a statement of information with the Secretary of State. That statement of information identifies who your officers, key officers are, the address of the business, and some other information. What AB 3075 does is creates a new reporting requirement that also requires the company to divulge any judgments against any officers or directors of the corporation or limited liability company. It applies to pretty much all fictitious business entities that are created through the Secretary of State. The law also makes it perjury, a crime to falsely report information about any judgments on your statement of information. Another thing that AB 3075 does is expand successorship liability. Now, successorship liability, a lot of employers in certain industries are familiar with this, but basically what it does is it allows a debtor, a creditor, to go after successor companies when companies try to avoid liability. Now, fictitious companies like corporations and limited liability companies, they exist in order to limit the liability of the owners of the company. Now, it's not uncommon for a entity to get a judgment against it. It's a fictitious entity. It closes up shop, creates a new entity that basically is in the exact same business, but is a separate legal entity under the law, and to continue operating as this new entity without regard to any judgments entered against it. Now, there's always been a way for creditors to go after debtor corporations when they try to avoid liability through a tactic like this. AB 3075 expands upon this in the wage and hour context and amends the labor code to create a new way to seek successor liability. And it creates basically 4 new tests. You only have to apply, only one of them has to apply in order to seek successor liability, but it allows basically an employee who has a judgment against their employer to then go after a successor employer or successor corporation just by proving one of the following. First, that the successor company uses substantially the same facilities or substantially the same workforce to offer substantially the same services as the judgment debtor, or, and you only have to prove one of these, the successor corporation has substantially the same owners or managers that control the labor relations as the judgment debtor. Third, the successor entity employs as a managing agent any person who directly controlled the wages, hours, or working conditions of the affected workers of the judgment debtor. Or 4, the successor entity operates a business in the same industry as the business, has an owner, partner, officer, or director who is an immediate family member of any owner, partner, officer, director of the judgment debtor. So essentially, to simplify it, what this law does is if you are an employer and an employee gets a judgment against you for certain wage about hour violations, and you end up closing up shop and starting a new shop that provides similar services or has the same employees or the same owners and managers and directors, the employee can then go after the new company for the debt that was created by that judgment. So the last law we're going to talk about is SB 1383. This law is a relatively minor change in the law that will have a major impact on a lot of employers in California. So first, a little background. There is a federal law known as the FMLA, or Family Medical Leave Act. Now, this law, this federal law, allows employees of certain employers to take up to 12 weeks of unpaid leave for certain qualifying reasons. The primary qualifying reasons are to care for the employee's own serious health condition, to take care of a family member with a serious health condition, or to bond with a new child within the first year after it's born. There's a few other qualifying reasons as well built into the law, but those are the three primary ones that come up most often. And most employees are familiar with FMLA, but they don't necessarily know the requirements. Now, one of the major requirements of FMLA in order to be eligible is, first, it only applies to employers that have 50 or more employees within a 75-mile radius. Now, California, back in 1993, passed a law called the California Family Rights Act, or CFRA, that is basically identical to FMLA. There's only one substantive difference between the law. In fact, CFRA uses FMLA regulations to guide it when it doesn't have its own regulations related to it. So for all intents and purposes, CFRA is identical to FMLA. Now, the eligibility requirements for CFRA up until now have also been identical, meaning it only applied to employers that had 50 or more employees. The SB 1983 makes a change effective January 1st that lowers that threshold to 5 employees. So now most employers in California, except for the smallest employers, are going to have to provide up to 12 weeks of CFRA leave to their employees. Now, this, if you have more than 50 employees, there's really no change in the law for the most part. CFRA has always applied to you, just like FMLA has applied to you, so the standards have not changed. But for all of those smaller employers, which are most of my employer clients, they are now going to need to make sure they comply with the leave requirements. Now, generally, in order to qualify for leave, the employee has to have worked at least 1,250 hours within the previous 12 months. That works out to roughly 24 hours a week. So this law applies to not just full-time employees, but a lot of part-time employees as well. Now, the biggest impact this law is going to have on smaller employers is not only do they have to give the 12 weeks of leave, but there's also many regulatory requirements that you must meet to comply with CFRA and FMLA. And if you don't follow those requirements, you leave yourself open to a lawsuit known as an interference lawsuit. That is a much easier claim to prove than a discrimination or retaliation lawsuit. Now, specifically, the CFRA requires that employers give notice to their employees. Now, this is very common that most employers are familiar with. If you have a poster hanging up in your break room or other area where most of your employers congregate at, if you don't, you should get one because there are many notice requirements in California law. But starting next year, there will be posters readily available for employers with 5 or more employees that have the CFRA on it. Now, even if you have less than 50 employees, most of the California posters already have CFRA information on it, so there really is no change to the poster requirement. However, one of the biggest impacts and one of the biggest things that interferes with employers in their compliance with CFRA and FMLA is the designation notice requirements. When an employee requests leave for a CFRA or FMLA qualifying reason, the law mandates that employers provide a designation notice informing the employee whether or not their leave will be granted or not. It also requires them to set forth how much eligibility they have left. So now employers are going to actually have to closely monitor, smaller employers are going to have to closely monitor these requirements and make sure they comply with the designation notice requirements. In addition, CFRA does allow employers to request medical certification before they grant leave. And there's very specific requirements that employers must follow when they request certification. There's only certain information they're allowed to receive. For example, they're not allowed to ask for the actual medical records of employees that identify the conditions that might qualify them for leave, but they can request and have the employee's doctor fill out a form explaining the need for leave and how long the need will end up persisting. There's also specific requirements relating to returning an employee to work. For example, you can require an employee to provide a fitness for duty certification saying they're fit to come back to work at the conclusion of leave, but you can only request that if you put it in the designation notice up front. And lastly, one of the most important things about CFRA in respect to employers is that CFRA is job protected leave. What that means is the employee has the right at the end of the leave to be reinstated into the same job that they had before, or if that job for some reason is no longer available, a similar job with similar pay and similar duties. And the important thing is, because it's job protected, there's only very limited circumstances where you'll be able to actually terminate the employee during the leave. So before you terminate an employee who requests leave, it's important, especially beginning January 1st, for all employers to consult with counsel before doing so to make sure that they don't run afoul of the CFRA leave. So that's the end of the presentation for today. If you have any questions, feel free to contact me. My information is on the screen. I can be contacted at matthew@thegreenlawgroup.com. You may also call me at 805-306-1100 extension 122. Again, everything we talked about today is meant to be a general overview. If you have any specific questions, please feel free to give us a call and we'll be able to help you out. Thank you very much.